walk us through your theory of the case here, and you've got it laid out in the Federalist. Everyone needs to go read this at thefederalist.com. And it says right here, the conduct claimed is perhaps unprecedented and certainly flagrant. If proven true, the judge would be well within her rights to consider dismissal. Let's get into the specific conduct that you've identified.
Sure. So the standard for dismissal of a case for prosecutorial misconduct is the misconduct has to be flagrant. What we have in this case is Walt Nauta, who is President Trump's co-defendant. He's a personal aide to President Trump. Walt Nauta's lawyer is a guy named Stanley Woodward. And Stanley Woodward said in a letter that he filed with the D.C. District Court that a senior DOJ official threatened his application for a judgeship, a D.C. Superior Court judgeship, if he couldn't get Walt Nauta to flip and testify against President Trump. Now, if that's true, what that means is that a senior DOJ official exercised undue pressure, attempted to strip Nauta of his Sixth Amendment right to counsel, and that would clearly be flagrant misconduct under the law. And if that's the case, Judge Cannon would be within her rights to dismiss the entire documents case, certainly against Nauta and probably against President Trump as well. But I think the key point here is that you're not hearing about this in the mainstream media. The mainstream media narrative, which Special Counsel Jack Smith has seeded, is that this is an open and shut, clear as day case against President Trump. And as we dig deeper and deeper into the actual facts of the case, and as we look into the Department of Justice's conduct here, we're just seeing more and more ways that the case is just not going to hold up. More and more ways that this whole thing may just end up going away.
And what would some of those ways be that you've identified? In addition, so this, of course, had to do with this idea of that the lawyer could have been appointed, given a judgeship, which I mean just sounds like an obvious dangle to me. But what are some of these other opportunities that you've noticed?
Sure. So the Presidential Records Act, President Trump has been talking a lot about this, but notably, the indictment does not mention a single time the Presidential Records Act. Now, the Presidential Records Act is the federal statute that governs how a president's documents and records are to be managed after he leaves office. President Trump's lawyers and President Trump himself have made the case that if these records were personal records, President Trump had every right to retain them. And under the law, every court that's ever looked at these issues before has said that a president's designation of personal versus presidential records, personal records versus official records, isn't reviewable. So you have these serious legal infirmities in the case that they've brought against President Trump, which as they're tested in court, there's a real chance that they just blow up in the special counsel's face. Another issue is the use of attorney-client communications. A big chunk of the case against Trump is premised on conversations that he had with a former lawyer of his named Evan Corcoran. Now, typically, those conversations would be privileged and the prosecutors wouldn't be entitled to use those conversations. I think that's another issue that President Trump's lawyers are going to challenge, probably successfully, as this case gets going. But if any of these issues goes Trump's way, I think it's going to be very difficult for the special counsel's office to continue prosecuting President Trump on these document charges. And I think that may be the reason why they're now looking to expand their investigation and potentially expand their indictment. They know they're on shaky ground and they're starting to get worried about it.